All right, are we all set?
Good to go.
All right, thank you. Hi, everybody, and welcome to today's webinar, Fair Chance Licensing, Regulatory Successes and Perspectives. This webinar is presented by the Council of State Governments Justice Center with support from Arnold Ventures, which has been instrumental in driving our work on fair chance licensing forward. So thanks to them, thanks to you for joining, and thanks to our two panelists, Deborah Blackburn and Edwin Neill, whose perspectives we're really excited to be able to share with you today. My name's Josh Gaines. I'm a project manager here at the Justice Center on our economic mobility team. And this is a topic we've been wanting to dive into for some time. So I'm really eager to get it kicked off by talking about the work the Justice Center has been doing in this area, why fair chance licensing is so important, and then turning it over to our panelists for the really good stuff that you probably haven't heard before if you've been following our licensing work. Before we do that, a bit of housekeeping. First of all, this webinar is being recorded and it will be made available on the CSG Justice Center website along with slides. So feel free to use that as a resource. Reach out for me if I can provide links for you. And second, we invite you to use Zoom's Q&A feature to submit any questions that you may have for our speakers. We'll direct as many of these questions as possible to our panelists at the end of their presentations. So a little background on the Council for State Governments and our licensing work. First of all, we are a national nonprofit, nonpartisan organization that combines the power of a membership association serving all state officials and all three branches of government with policy and research expertise to develop strategies that increase public safety and strengthen communities. We work by bringing people together, and we drive the criminal justice system forward with original research, and we build momentum for policy change. We also provide expert assistance. Our goals are to break the cycle of incarceration, advance health, opportunity, and equity, and use data to improve safety and justice. Our Fair Chance Licensing Project, which this webinar is a part of, is aimed at assisting states in economic recovery, enhancing access to well-paying jobs, and improving reentry and public safety, also providing businesses with qualified candidate pools. And we have a fair chance licensing hub online that kind of tracks the work that we've been doing, and more importantly, the work that states have been doing, best practices and the like, what states have done what in terms of adopting those best practices, stories from people in the field, stories from legislators, just a whole wealth of information about this. So I encourage you to visit that. And as soon as I'm done speaking here, I'll put a link for that site in the chat so that you can visit it. I want to just provide a little bit of context about why this work is important. A 2022 analysis of the Prison Policy Initiative by the Prison Policy Initiative of some US BJS data tracked the progress of a cohort of people released from federal prison in 2010, and it found that 33% never found a job in the first 4 years after release. 60% or more were jobless at any given time during those 4 years. And for those looking for work, the unemployment rate remained around 36% during all 4 years. I don't think this is news for anybody that it is exceedingly difficult for people with criminal history to find work. And it's not just work, it's good work, it's sustainable work, it's career pathways that really allow them to follow their ambitions and to advance themselves. Going back to that data and in that context, for the people who found jobs, most were unstable and earnings were far below the US median income. That was based on some older data from 2010 that was just compiled in 2022. But we see this, similar data reflected in other studies. So 2022, Rand Corporation's study estimated that 46% of unemployed men have a conviction record for a non-traffic offense by the age of 35. So the problem is enormous. Complicating the matter or exacerbating the problem is the fact that gender and race play into this, and it's not felt equally by people of all genders and races. So based on that prison policy data, and there are links to this research at the bottom, and I encourage you to look at that if you're able to pull up the slides after this has been broadcast. looked at joblessness rates among formerly incarcerated people and among the U.S. population. And what's really stark about that, you can see the differences here, first of all, with general population on the left and formerly incarcerated on the right. The biggest disparity is among Black women, who have a 6.4% jobless rate in the general population, but a 43.6% jobless rate for formerly incarcerated. So the issue breaks down very differently among different communities. So why licensed work? Why is that important? Well, 20% of the US population holds a license that is required to perform a particular occupation or profession. And it seems that that number is going up. Back in the 50s, it's estimated that about 5% of jobs required it. So more licensure requirements equals more people who need a license to do their work. Licensed jobs tend to be better jobs. On the hourly wage that licensed workers earn above unlicensed workers, the national median is $7.36. So most people with licensed jobs are earning more than unlicensed people. Having said all that, there are 13,000 plus provisions of state and federal statutes and regulations that create barriers to licensure for people with criminal history. So access to those licensures or those licenses and those jobs is especially restricted for people with criminal history. A third of those things, those licensing barriers that are imposed by law, are mandatory. They're imposed no matter what. If somebody has a disqualifying conviction, there's no discretion on the part of decision makers to allow somebody who may have a potentially disqualifying conviction to enter the licensed profession. And 3/4 of those barriers persist indefinitely, which means they could prevent you from obtaining licensure at any time in your life, regardless how long ago it was that you were convicted of an offense. And I talked about those mandatory barriers, kind of automatic and discretionary barriers. They're important in that, you know, if a barrier is mandatory, you're just absolutely not going to get the licensure. But discretionary barriers aren't necessarily much better because of the deterrent effect that they have. So just to kind of put an example forward, think about someone wanting to pursue a career in physical therapy and needing a license to do that. In many states still, in most, I'll say, they have to invest years of time in obtaining the training they need for licensure. They need to invest thousands of dollars in tuition for school, for books, whatever else it may be. And once they have done all that, then they can apply for licensure. And maybe if they have a conviction that might be disqualifying, get the license, but maybe not. And regardless of where that would, land for them as an individual, they have no way of knowing the answer to that question ahead of time. So people are having to assume enormous risk before they can even get a decision. And for many people, especially people with criminal histories who we know tend to be economically disadvantaged, that risk is just too much to bear. So these discretionary barriers often keep people out of licensed work, even if they would be qualified for the license ultimately. So how have states dealt with that? Well, over half the states have enacted broadly applicable fair chance licensing laws in one form or another. And these are based on three key principles, really. One is that licensing bodies ought to have the authority to deny applicants with past convictions if they directly relate to the tasks and duties of the licensed activity. Second is that workers shouldn't be barred from licensure solely because of a past conviction. They should be given individualized consideration that accounts for their past and current circumstances and the nature of their criminal conduct. And then finally, licensing policies and practices involving determinations about criminal history should be transparent and consistently applied. And if you go and look at our Fair Chance Licensing website, and again, I'll post the link in the chat here in a bit, we kind of give a rundown of sort of how states have put those three principles into action through policy. And we've really broken it down to a set of best practices that's reflected here. I don't want to go through all of these, and I'm sure our panelists will touch on a number of them. But the big categories are really substantive guidance on how licensing boards and agencies have to consider criminal convictions. The third is transparent and accessible procedures and protections. And then finally, limits on the types of convictions and dispositions that can be considered. And again, if you're interested in looking at any more of those studies, you can find this slide again on our website and dive into that some more. And I do recommend, if you're interested, you do that, because there's some really interesting stuff in here. All right, that brings us to our first guest, Deborah Blackburn, who's been instrumental in making reforms like these work in Colorado and in developing policies and practices that help translate those lofty reforms into impact on the ground. Deborah's the Deborah's the Assistant Director of the Utah Department of Commerce's Division of Professional Licensing, otherwise known as DOPL, which oversees approximately 60 categories of professions and several independent programs. Deborah joined DOPL after 20 years in private practice as an attorney. As a second career, she enjoys finding ways to remove unnecessary barriers to licensure while effectively balancing regulation and public protection. And Deborah's a mom of three remarkable women, and Mima to two perfectly messy, as she describes them, grandchildren. So thanks for joining us, Deborah, and take it away.
Yeah, thanks so much for having me here, Josh. You're singing my song. I'm so passionate about these issues, and I'm just really excited to share the work that we've done in this area. I feel like we've done a lot very quickly, and I'm a little surprised about how much we've been able to do and how welcoming the community has been about it. So again, DOPL, we've got 8 bureaus. We oversee those 60 categories of licensure. So physicians, surgeons, engineers, cosmetologists, contractors, nurses, pharmacies, just tons and tons of different types of licenses. And we have our own Bureau of Investigation with about 40 investigators. So we do see that whole broad range, and we see all these pinch points with the criminal history. So I joined DOPL in about mid-2016, and we really did at that point, I felt there were a lot of denials for criminal history. As you mentioned, those statutory barriers, those discretionary barriers, just really tough for people with criminal history. But I felt like our managers here and our staff were just so amenable to change and really did see these problems and took them to heart. So I'm just going to jump in. At that time, for licensing and disciplinary actions, per statute, we had to consider whether a person's criminal history was reasonably related to their ability to safely or competently practice. And reasonably related is a problem because you tend to go down the rabbit hole. There's a what if parade of horribles. Well, this cosmetologist has a theft conviction. Oh no, she could get in someone's purse. You know, is one DUI, is that reasonably related to a CPA's ability to practice? What about 2 DUIs? You get into those conversations. But in 2019, our director, Mark Seinigal, he helped with some bill language that had come, and there were some proposals. As I recall, there was a whole page of language. He said, why don't we do this key policy change? And we did it with one tiny word change. We changed the term reasonably to substantially. And my joke was, this is one small step for man, one giant leap for mankind, because we just had a better change of philosophy, a better tipping point. So we now ask, is the person's criminal history substantially related to their ability to safely or competently practice? I guess go to the next slide. And again, the substantially gives us that better tipping point. We can focus on what's important in protecting the public and let people work who are actually able to safely work. So this, what I thought was a significant shift in philosophy. It guided our next efforts. So we sent out letters and met with each of our 50+ boards, our licensing boards for each profession. And we discussed in detail, and it took about a year to go do all this. What exactly is substantially related? So which criminal behaviors, when they're considered with the specific duties and functions of your profession, do bear a substantial relationship to your ability to safely or competently practice? And this is one of the fun things with so many professions. There are so many different cultures. Our engineers are nothing like our plumbers, are nothing like the contractors, are nothing like, you know, just on and on. Really some fascinating discussions. I was just going to give one example. Our veterinarians, of course, they, looked at these convictions. They said, we're not worried about burglary. We really don't worry about that, but we are very concerned about controlled substances offenses and acts, because they have access to controlled substances. It is a big problem for them. The CPAs, they said, we are concerned about burglary, forgery, anything related to theft. So that's what they focused on. So I just kind of where the rubber hit the road was really good. So next step, I guess, go to the next slide. We're gathering all this data. We're trying to be more objective and consistent. So now what? How can we share this with our customers and be more transparent? And so we created these new criminal history guidelines along with frequently asked questions to try to explain what criminal history we consider and how. So if you go to the next page, we kind of, what we do is, I'll just read the screen. Every profession, we have a landing page. And so we have this criminal history tab. And so for information specific to that profession. And go to the next one. I want to show you what they look like. We kind of jokingly call this the matrix. So here's our guidelines, and you can see the key on the screen. I don't know if you can see me pointing, but the green is issue, the application, not a problem. Review is blue, and that's either the manager review or an interview with the board to review these. And red, which looks pink on this screen, is deny. Licensure is prohibited for this. So I guess you could run that play button. The types of charges are on the left-hand side. And what we did is we tied this to our criminal code. So these are the charges that are in Utah code. And across the top, when it's done running through, there's quite a few. So if you go back to the top, you can see there's a time frame. And so we're looking at between, is the last conviction or plea, is it between 0 and 1 years? Is it between 2 and 5 years, 6, 10 years, or 10+ years? Because that really mattered, how long ago that this happened. So the key is when you actually look at most of our guidelines, to me, maybe it was kind of a surprising thing. You see lots more green and blue than red. We just ran through the contractors, but of course, there's some professions that are more sensitive to criminal history, and many crimes are going to be substantially related to their ability to practice. So if you go to the next slide, I just want to show you security guards. If you want to run through that, they have statutory language prohibiting 2nd and 3rd degree felony charges. And these are, arson, burglary, rape, very much substantially related to their, the functions of their profession. So there's a lot of support in DOPL for this concept of substantially related and removing barriers. So I'll just kind of give you an example how people get on board with this. Another area of reform we've tackled is licensure by endorsement, allowing people from other jurisdictions to come practice in Utah. If they're licensed in the other jurisdiction, they can come get a license here on a more streamlined basis. And so when the legislature was working on the initial bill, the bill language banned all applicants who had criminal history or discipline from using this pathway. And one of our bureau managers looked at the proposed bill language and said, well, why don't we just change this to discretionary review so it fits in with our guidelines? That way we can, deny review, not 100% ban. And they worked with us and they did that. So that I don't know, I just love that. So the fact that we're all just working really hard to make this work for everybody. And again, these are living documents. So we review them based on legislative changes and review and input from our boards. Kind of a fun example, just last month, we have new legislation that became effective. So there used to be an outright prohibition on getting a nurse license if you had a violent felony. And that's been deleted. And now it's treated like any other conviction or plea. So you can see on here, these are nursing guidelines. This is a screenshot of the old ones. There's a lot of deny. And if you go look at that today, which we have only gotten it up a short while ago, you'll see lots more green and blue. So issue, proceed with the application, or just review. So kind of back with our general standard of looking at those. So you go on to the next slide. So again, we're just kind of asking, how can we be more objective and consistent? That's sort of the mantra. So another thing we did, and I think this was in the 2020 session, we asked in our division bill to remove this, what we felt was an ambiguous and subjective good moral character statutory requirement. It was in every single profession, I believe, and my director really felt this had to go. He said, and the funny thing was, the reason we have this character up here, when we presented on it, there was actually a lot of pushback. People are saying, "What? You're removing good moral character? What are you doing? You're just letting anyone in." And what we said is, no, we are focusing on convictions and pleas, actual things that happened. We're not going to do these subjective standards where we leave people guessing about what we're going to consider for licensure. So if you look in our statute now, any reference to good moral character or moral turpitude should be gone. And the reason it took us almost 3 years to get these out of, we have, I think, 70 different practice acts plus our umbrella practice act. They kept missing them. One showed up for landscape architect, and I kept looking at it for a whole year going, I want to get you out of the statute. So, anyway, I want to highlight too, Josh, you talked about the individualized consideration. If you go to that one. So we were really already doing this, the individualized consideration, but we had another bill introduced in 2020 that specifically supported our efforts. And I think this was based on language that actually was introduced in a lot of legislatures nationwide, but we worked with the sponsor on the final language to make sure it kind of fit in with our guidelines and what we were doing. So there wasn't confusion or more barriers. So but this is now in the statute, which we really like it when it's in the statute because we can just point to it. So again, everyone can read it, but we look at the age, time elapsed, completion of sentence, rehabilitation efforts. What have they done? Have they pursued education or training? What's their employment history? And we look at all the testimonials and recommendations. Are there teachers? Are there parole officers that want to explain, how well they've done? Basically any relevant information they want to provide. So, and if you go to the next slide. So another bill that was introduced, it specifically allowed us to not consider as unprofessional conduct an arrest not followed by a conviction or convictions for which the incarceration had ended more than 7 years before. And there's certain exclusions for some felonies, but the interesting thing is we were already not considering arrests followed by convictions. We already weren't, you can see on our guidelines, for the most part, we weren't considering these incarcerations. And I think it actually dovetails perfectly with our guidelines, based on the felonies. But it feels good to get it into statute as well, because it gives us that guidance and the consistency and the assurance that when the board membership changes, that is going to continue on. So I think I feel pretty good about that. That last one is expunged crimes. This was an interesting one because historically we had authority to consider expunged crimes, but we had an informal, again, internal policy that we did not consider them. And last legislative session, we informally supported a bill that removed our agency from the list of agencies allowed to review expunged information upon request. And again, our staff is so supportive. When we polled our bureau managers before weighing in with the sponsor of the bill, the resounding response was they said, we don't need to see expungements. We've never used them. We don't feel it would be useful or fair. Why second guess the court's decision for somebody who's already served their time? So again, we're like, yes, please get that into statute. We're glad to support it. So again, just the continued reforms, these additions to language, they really have fit neatly into our guidelines and our focus on actual convictions or pleas. I think it's worked pretty well. Just another example, just this year, there was a proposed bill about us not being allowed to take action against a substance use disorder counselor if they'd had these drug convictions after 3 years. And we talked to the sponsor and said, we already don't do that. Here's our here are our guidelines. This is where we don't consider it. And so, and sometimes our guidelines are more permissive than what the sponsor intends to introduce. So it's actually been a really win-win for what we can consider. Let's see, let me go on to the next slide. So again, we try to have overcome this mentality of we've always done it this way because things become so entrenched. And sometimes it feels good to check a box and feel like you're protecting the public. So this is an example. We have a questionnaire that every single applicant for a license has to fill out for all of our professions. And again, we're trying to be objective and consistent. And if you look on there, we've got 12 questions. And this questionnaire was just, we're feeling it's really over the top. I'm just going to read one of the questions, which I try not to roll your eyes. So, are you currently using or have you recently within 90 days used any drugs, including recreational drugs, without a valid prescription, the possession or distribution of which is illegal under applicable state or federal laws? These were just not useful, and it kind of felt like a gotcha, and it didn't fit in with our concept of, we're focusing on actual convictions, we're focusing on pleas. So if you go to the next slide, we changed our questionnaire. We now have 4 questions. Basically, have you ever had another license? Have you had the discipline on that license? Second, do you have any current criminal action pending? Third, within the last 10 years, has there been a misdemeanor, and has there been a felony? That's it. 1, 2, 3, 4. It's simpler for people, and we've kind of gotten away from that gotcha. Again, we're just focusing on these actual convictions. So let me go last, and this is last but not least for me. This is, and Josh, you touched on this a little bit as well. This is an advanced criminal history determination, and this was Representative Hutchings in Utah introduced this here. And this is a pre-licensure criminal history determination. And this allows an individual to ask DOPL if their specific criminal history would affect their ability to become licensed in the future for the specific profession of their choice. So, and this determination, it's available even before they pursue training or education. They can have done nothing of this. If somebody interested in becoming a physical therapist, they can have nothing, and they can come to us and say, here are my convictions, here's my history, please consider this and let me know if, based on, of course, the laws as they stand today, would I be prohibited from licensure? And so they submit the application, we review it, we issue the written determination within 30 days, and we tell them if their crimes would prohibit them from licensure. And I grabbed some stats for you. So this is over about 3.5 years. We've had about 117 applications. They're mostly nurses, and then contractors. Contractors tend to have the more serious, criminal history. Cosmetologists, massage are the other ones that tend to be the bulk of these. And most determinations have been favorable. We say we would approve your future license application with this criminal history. And we just say, but you have to tell us everything, because it's only based on what you've submitted to us. And of course, it has to be based on the laws today. We don't know what the laws, might be like in 5 years after you get your education. But for the most part, things are pretty consistent. It gives them a really high degree of security that, the big bad bureaucrat has looked at this and given you a thumbs up, and you have a letter from us saying, yes, we've considered this and you're good to go. So, so we've had only 19 unfavorable so far. Again, most of those are contractor massage therapists with some really serious history. Most of these have been denied as incomplete. People just haven't submitted their full history. We say, please give us your history, and they just don't continue. They don't follow up. So in summary, we've just done some major changes in our consideration of these applicants, and even existing licensees who have a criminal history. They all fall under these guidelines. So we've got this minimal criminal history questionnaire focused on the actual convictions and pleas. We've got these published frequently asked questions to help answer questions. We've got this new lens, the criminal history has to be substantially related to this person's ability to safely or competently practice. We've got a lot of barriers that have come down. In statute, we now say we don't consider standalone arrests. We don't consider certain convictions at all, including legally expunged crimes. So we've got our new guidelines, which are living documents, say what crimes matter to what professions. And we try to focus on those and only on those. So, and then the new advanced criminal history determination. So, will my criminal history will affect my ability to become licensed in the future? Just trying to be more objective and consistent and transparent. We want to protect the public, but just make sure we remove unneeded obstacles. And like, again, things can always be improved. We keep looking at this and we intend to keep looking at it, and we just want to get better and better. So I'm going to put in the chat, let's see, where people can go and look at our criminal history guidelines and play around on the website and see. And again, if you have any questions. So thank you so much for having me today. I'm excited to brag a little bit about what we've done. So I feel like things are moving in a really great direction. I feel like this just strengthens communities. Is there anything better than being able to work in a career that you love and make good money, and any better way, not to go back and reoffend?
Excellent. Thanks for that. And just we'll pull some more questions after we hear from Edwin, but I did want to ask very quickly how involved, and preface this, when we talk to states about this, doing this work, this led us to you, is we use Utah's matrix and their kind of online information sharing, making it very accessible. We use that as a model when we talk to other states. I'm wondering how involved was DOPL in making those decisions about the matrix versus the individual licensing boards or agencies, and whether you think a similar approach would be feasible in states that might not have, and for people who don't know, maybe you can elaborate on this, might not have a strong umbrella agency like DOPL overseeing, the nuts and bolts of licensing in the state.
Right. Yeah, I'll just, and I'm sure probably everybody on knows this, but we're an umbrella agency. So our boards are advisory. We have all these professions. Most of them have a board that are the experts and they advise us, but they don't necessarily have the power. And we have a construction services commission that has equal authority, but if we disagree, our decision carries the day. So we can just impose our will, I suppose, is another way to say it. But the really important thing about this is to get the buy-in of the board, the support of the board, really the expertise of the board. They're the ones that know their profession. And so just to build the relationships with them and not just impose it top down, what we do is explain what is the shift in philosophy, explain our tipping point, what is substantially related. And the boards, I felt really embrace this for the individuals really embrace this on the board. It's kind of a sea change when they say, oh, you're right. If somebody gets this DUI and, on Saturday, is it really going to affect their ability to show up on Monday? They really have thought through this. I was really impressed. So could this work with an autonomous board? I think so. I think if you explain the philosophy, and give them the power to do it, it's them that's creating the guidelines. We helped with this, but we didn't create. We go with their recommendations. And, we do point out, if there's a conversation, well, is this substantially related? And honestly, they've been so good.
Excellent. Thanks so much for that. And we'll come back with some more questions here in a bit. I do want to introduce our next panelist, Edwin Neill, to bring us maybe a bit closer even to ground level on these issues and shed some light on how partnerships between licensing agencies, corrections, and employers are helping to put folks to work in licensed jobs. Edwin is both the chairman of the Louisiana State Board of Cosmetology and the CEO of the Neill Corporation, which is a leader in the beauty industry, where he's responsible for the overall strategy and business of the company, including the primary businesses of Aveda Distribution for seven southern states. That was a tricky one. Aveda Arts and Science Institutes, Neill Fulfillment, and Paris Parker Salons. Prior to his time at Neill Corporation, Edwin practiced commercial litigation at the New Orleans law firm of Stone Pigment. And Edwin received both a bachelor's degree and a law degree from LSU and his MBA from Tulane. Edwin, thanks for joining us today. And I'll let you take it.
Thanks for having me. Thanks, Josh. And Deborah, that was it's amazing what you guys have done in Utah. It's really impressive. So I just want to start by really sharing a positive story about a regulatory board helping an extremely disadvantaged group get licensed. As Josh said, I served as a chairman of the Board of Cosmetology for the state of Louisiana, and the board regulates over 40,000 licensed cosmetologists, estheticians, and nail technicians, and about 5,000 salons. So there's a separate board for massage. We don't regulate massage, but we regulate those three disciplines. So not long after I joined the board in 2016, one of the district judges, Trudy White, came before the Board of Cosmetology with an idea to create a program in the prison to teach hair to inmates at the Louisiana Correctional Institute for Women. The prison system already had certification programs in culinary arts, horticulture, welding. So she thought cosmetology would be a good addition. And it sounded like a great idea. The problem was finding how do you get instructors in the women's prison. You have to be licensed to be a cosmetology instructor in Louisiana, as in many states. So, when you think about the expense of trying to pay someone and send them in, it seemed insurmountable. But about 6 months later, Dr. Sanders, who's the head of career and technical education for the Louisiana Department of Corrections, came up with an idea and came to the board with a proposal. His thought was to identify women who were already incarcerated with long sentences in the Correctional Institute who had cosmetology licenses. And it turned out there were a few. He found 4. And then if we were able to train those women to become instructors, then they could teach their peers and they could be the instructors in the school. So people probably have heard this, but Louisiana has one of the largest percentage of incarcerated people to population in the entire United States. The Louisiana Correctional Institute for Women was originally at a town called St. Gabriel. It was totally destroyed during Hurricane Katrina. They moved the women's prison to the old juvenile facility, which is north of Baton Rouge. And the LCIW currently has about 1,100 prisoners, many of whom are convicted of drug crimes, other non-violent offenses. And this surprised me that 80% of the inmate population there has children. So that's a lot. You think about people getting out of prison, a lot of single moms. So the Board of Cosmetology, there were some regulatory barriers. First, we had a rule that to have a school in the prison, it was going to be a very small school. We had a minimum square footage requirement. So the board waived the square footage requirement because the school wasn't going to be open to the public. We also had to work with the Department of Corrections to accommodate testing. The inmates were going to have to come in and test in a special session that would be closed to other applicants. So the other big issue was, what Deborah, you've been talking about was, there was a provision that said that if you had any criminal conviction, the board had to review it and decide whether or not you'd be eligible for a license. Well, the board really felt like that gave us too much discretion. And when you think about what a person does in a salon, you're in public. It's not, I understand security guards, massage therapists, people who are handling money, all of that. Boy, you can see why there were some offenses that people would be concerned about. So, but we really couldn't figure out what we would say no to in cosmetology. So we went ahead and passed a rule, and Josh, if you can show my first slide, that, which the board had the authority to do. We said applicants shouldn't be disqualified or denied issuance of a certificate of registration based on a prior criminal record. So we just took all that discretion out of our hands. And in my time on the board, we had not reviewed a single criminal conviction to determine whether or not someone would be licensed. So it seemed like the right thing to do to just take it out. So with those regulatory hurdles cleared, the next question was how to get these instructors certified. So what we did was we sent in an instructor, Aveda Arts and Science Institute. We sent in our instructor to train those 500 hours for the ladies in the LCIW. And the next slide, I have a picture of this is me at the little beauty school there at the women's prison. And these are the 4 instructors are there with me and a couple of the members, the staff members of the Board of Cosmetology. So next slide. We sent in our instructor, Lauren, at Aveda Arts and Science Institute. She was at the school closest to the women's prison. And she was really passionate about the people at the LCIW and the work she was doing. She said she's never seen a more prepared group of students. And if you think about it, I mean, you guys probably know this. I mean, every women's prison has a hair salon. So you have to have a hair salon. It's an essential service. So the salon was already there. We already had hairdressers there, and there was a huge demand to be a part of this program. They only accepted 5 students, and I think the next slide is, this is a slide that shows the instructors taking their examination to get their instructor's certificate at the Board of Cosmetology. You can see one lady even is in shackles in this picture, but they all 4 of them passed with flying colors. One of the ladies had a bit of a learning challenge, so we had the written portion of the test had to be done verbally, but once we made that accommodation, she was able to pass too. So all 4 of the ladies who were hairdressers in the prison got their teacher's certificates. The program has now been expanded to a second women's facility, the Louisiana Transitional Center for Women in Tallulah. And that means that both women's prisons in Louisiana have cosmetology programs. Next slide. So by February of 2022, these first 5 ladies on the left were able to graduate from the program and receive their license in Louisiana. So when they are released from prison, they will be able to practice cosmetology. And I think licensing comes under a lot of criticism, but I think this is a case where it shows how it can be really important. Because I think if a person got out of prison, went to a salon and said, I did hair in jail, you should hire me, it just doesn't, I mean, without that license, there's really no proof of what they can actually do as a hairdresser. So there's a written exam, a practical exam to become a hairdresser. So they're certified, they've been trained, they know how to do hair at this point. So a second class has already completed their coursework and they're finishing their testing now. And our latest news is one of the instructors from the LCIW in the first slide, her name's Karen. She's been released and actually reached out to us about getting a job, and Aveda Institute has hired her as an instructor in cosmetology at the Aveda Institute in Covington, Louisiana. So it was really the feedback that we've gotten about her is she's a passionate instructor, and the team is really excited to work with her. So I think cosmetology education and licensing is a force for good in Louisiana, and it's providing opportunities for women who are incarcerated to learn a skill and receive a credential, and they can rejoin society as a productive member. So that's what we're doing here in Louisiana. And thanks again, Josh, for having me on.
Absolutely, and thank you for joining us. I'm curious, you touched on this a little bit with the expansion of the program, just your thoughts about the scalability of a program like that, whether there's been talk about expanding to other institutions, maybe even men's, and what challenges might be involved there.
Well, the men's prison, they have a barbering program. So And I think that that is something that is working extremely well. This is the both facilities that, longer term facilities in Louisiana now have the program. But I think it certainly is something that if other states aren't doing cosmetology in their women's prisons, it's something they should definitely look at, because I think, as I mentioned earlier, that Christy, the head of vocational education at the facility, tells me she's got, many more people who want to be a part of it than she can even accommodate, in a facility. So it's a popular program.
Excellent. I wonder too, if, wearing your hat as an employer, how fair chance licensing policies and programs like that in Louisiana benefit employers, and just kind of what the intersection looks like. I know you talked about hiring on, but just in a broader sense.
Yeah, well, I think for cosmetology, we have a massive labor shortage of cosmetologists throughout the country. Cosmetologists are in high demand. So this is certainly a way to address that. And also, we're always looking for qualified instructors, and I know other beauty schools are too. So as far as an instructor pathway, I think that's something that is important too. I mean, to be perfectly frank with you guys, we do have a background check at our company, where we ask about criminal conviction. And, when Karen was applying, I spoke with the head of HR. I said, you can do a background check. She's definitely got a criminal conviction. So for me as an employer, it really raised the question about, what should we be doing about background checks? What's appropriate and what's not appropriate?
That's great. Thanks for that. I want to pivot a little bit, just coming off of this sort of direct engagement with workers with criminal histories who might be interested in a path towards licensure, and ask Deborah whether you're aware of DOPL taking any steps to engage with workers with criminal histories, either directly or in partnership with other agencies or organizations. I think I had heard of participation and possibly job fairs, or maybe even expungement clinics or the like. Right. But I'd love to hear some more about that if you have anything you can share.
Yeah, that was one of the things that we did. Was Salt Lake City and has a partnership with the Utah State Bar, and they put on expungement clinics, and we got to participate. I think it was their first annual, and we participated in them. The pandemic made it harder. They tried to do it virtually, but what we've done is show up to it, answer questions, hand out, little cards, QR codes, go to our website. Hey, just so you know, you can get a license more easily perhaps than you would think. And if you get this expunged, you're going to have even more careers open to you. So I really loved being a part of that. If you go to our frequently asked questions, there's a question on expungements, and we try to put links out to, to various agencies that will help with that sort of thing. So that's one example. Job fairs, things like that.
Excellent. And turning back, well, first we've got a question in the chat, and this may be more of a technical question, I believe for you, Deborah. Do you feel that per your code, and I guess that's the general licensing statute, that any type of conviction could be accommodated barring a direct nexus between the conviction and the scope of work, which I am reading as, is any conviction, are there convictions that would never be, I guess, is no conviction disqualifying if there is a nexus between, if there's not, pardon me.
Oh, well, I guess to just kind of interpret the question, maybe give a couple of hard examples, barring the statutory denial, which that's a bar, and that's for the legislature to decide. But there are accommodations that can be made. For instance, just to get specific on contractors, electricians, plumbers, we see people who are on the sexual offender registry. And we accommodate that by, we don't deny the license, but we tend to put them on probation. Of course, we look specifically about what was involved, where, look at, that one definitely goes before the Construction Services Commission. But what will typically happen, they'll put them on probation. So they'll be on a probationary status as long as they're on the registry. It's just tied to however long they're on the registry. And if there's any concern about minors, they'll have a prohibition. You cannot work in any area where minors are present, and you have to notify us of any events that have happened, any criminal history that's happened at all. And the other, let's see, and they need to work in commercial areas. They're usually barred from residences entirely. So that's just kind of one example of how we could accommodate. One great conversation I had with the CPA board, I just happened to be there that day on another issue. Somebody had applied for licensure and they were reviewing, and he had been convicted of child pornography. And again, they have that discussion based on the matrix. Do we deny? I think he was an existing licensee. So the question is, do we revoke licensure? What do we do? Do we suspend? They allowed him to continue to practice, but they made sure, what is the situation? Who is he working for? So make sure he's working at home, make sure he doesn't have access to online, anything else. So they weren't interested in barring him from practicing. They were just making sure that his practice would be safe. So I think that might answer the question.
Yeah, that's great. That's really interesting.
It's again, it's
case by case that really gets to the individualized consideration and beyond.
We do look at patterns. Our matrix. Our joke is it matrices or matrices? The guidelines that we have, we do look at patterns. So if the look back, like 0 to 1 years, we look at the conviction within that time. But if there's a pattern of convictions, we're certainly going to look at that too. So
great.
And back to such unique circumstances.
We have just 6 minutes left and 2 questions in the chat. One is, I think, really good, looking for just some more of the kind of nuts and bolts and how the pre-application qualification process works. And I hope we can direct folks to you for answers on that offline, if that's okay with you, Deborah. Another is asking how Utah compares to other states. And they're interested in Florida. I can answer that briefly if you don't want to toot the horn of Doppel yourself, Deborah, which is Utah.
Yeah. No, you toot it for me, please.
I would encourage you to go look at that Fair Chance Licensing website. I put the link in the chat. That really goes over what policies are in place in every state. There's actually 50 state maps where you can see for each one of these what state has it and what doesn't. Utah is absolutely top tier. And as I mentioned before, in terms of getting that information out to the people who need it, making it accessible, it really is a model that we don't see replicated in enough states. So I would definitely encourage you to look at both links, the link to the Doppel site about criminal history and to ours there. We have 5 minutes left, and I just want to leave you both with the last word. Based on your work in this or on this issue, do you have a lesson or just a thought that people from other states, maybe people in other industries, can kind of take forward from your experience? And we'll start with, I guess, Edwin, if that's okay.
Sure. I guess really the thing that I think worked really well in Louisiana was the work done between the Board of Cosmetology and the Department of Corrections. That partnership was pivotal into getting our program going and to really raising the consciousness of the Board of Cosmetology about, the difficulties people had after they got out of prison. Dr. Sanders, one of the things he says is we're all one one mistake away from being incarcerated ourselves, one bad decision. And there's a lot of truth to that. So I just think that hearing from them and seeing the passion that the people at the Department of Corrections have about getting the people who finish their terms in prison, getting them jobs, really got the board behind making these changes.
That's great. And Deborah, any closing thoughts for other states?
Yeah, I think where we have had an advantage, my director's been in this game for, not the game, but for a long time, and he's worked with the legislature for years, and he was previously a policy analyst at the legislature. So he understands how important partnerships are and collaboration. And a lot of times the legislation is based on an anecdotal experience or a one-off, and they'll propose something, and he's just having that partnership and that trust has been so wonderful to say, oh, I see your concept. Let's work with the language. Let's see what we can do to accomplish what you need to do. And so something that might go off the rails can be changed to be something really powerfully good. And I think that's been so important, just to be, like I mentioned, that little tiny word change, one small step for man, one giant leap for mankind. That was just such a stepping off point for us. And just having that relationship with the legislature was so important.
It's great. And both really powerful points to end on here. I want to thank you both for joining us. This has been really great. Viewers, I hope you guys have gotten as much out of this as I have over here. If you have questions, you can reach out to me. I'm happy to put you in touch with Deborah, Edwin, please feel free to join our mailing list, check out other resources and work that we're doing here at the Justice Center. Thanks again for everyone involved, and we hope you have a good day.
Thank you so
Thanks,
much.
everybody. Bye, everybody.